A very good morning to Madam Ainul Mardia and to my fellow friends. Hello, my name is Muhammad Aizat bin Rudy, and today me and my team will perform a presentation. We will present a case summary of Lee Ting Fong vs MyBiz Malaysia Sendirian Berhad. The background of the case. This case was disputed in an industrial court, that is a court to disputes between employers, trade unions of employers, trade unions of workmen, by the Honorable Minister of Human Resources, and this case took place on 10th April 2013. The case involved the Industrial Relations Act 1916-17. This act is an act to promote and maintain industrial harmony and to provide for the regulation of the relations between employers and workmen, and also the trade unions. So the claimant was a female worker known as Lee Ting Fong, and the respondent was a company namely as MyBiz Malaysia Sendirian Berhad.
Assalamualaikum and a very good day. My name is Hani Humaira binti Hazaini, and for the presentation, I will explain about the material facts that can be found in the case of Lee Ting Fong versus MyBiz M Sendirian Berhad. The first material fact is Lee Ting Fong notified her employer, MyBiz M Sendirian Berhad, that she considered herself as having constructive dismissal as her payment of June and July salary were delayed. Constructive dismissal means the changing of an employee's job or working condition with the aim of the forcing of their resignation. Secondly, in a particular year, the company did not pay her August salary and all her claims from April. The third material facts, the company did not reply to her letter which declaring the constructive dismissal. Following the unresponded letter, the company also failed to give the real reasons of the delay in her payment of salaries and claims, and the reassurance that were made by MyBiz also not met. The claimant said that the company, MyBiz M Sendirian Berhad, had fundamentally breached their employment contract with her, as well as the implied term of mutual trust and confidence.
Assalamualaikum and good day. My name is Siti Zulaika binti Jasiman, and I will explain about the court's decision of the case. After taking all the proof, facts, and the rules of law in the Industrial Act 1967 to behave on the basis of equality, good understanding, substantive merits of the case with regard to the technical details and legal form, the court found that the claimant has established that the respondent had refuted the employment agreement by its action. The claimant also qualified to consider herself being constructively dismissed by the respondent. The court also finds that the firing of the claimant was without cause or justification. Then, the court allowed the claimant's claim and awarded her 67,830 ringgit in back wages and compensation in lieu of reinstatement called monetary compensation. For this, the claimant will be paid with 24 months back wages with a total of 151,200 ringgit as of the dismissal's date 6 September 2001, with consideration that the claimant has worked for 1 year and 2 months. In addition, the claimant should be paid in lieu of reinstatement regarding her 1 month salary per year of complete services, with a cumulative total of 7,350 ringgit. The claimant also defined that her monthly salary was 10,000 ringgit along with 1,000 ringgit car allowance and bonus for 2 months. Furthermore, the court decided to reduce the back wages award by 60% as fair and sustainable. As a final result, a sum of 60,480 ringgit and 7,350 ringgit ordered by the court should be paid to the claimant's solicitor within 30 days from the date of the award.
Assalamualaikum to Madam. My name is Nur Asnia Dania binti Johar, and I will be explaining about the legal issues of the case. In the case Lee Ting Fong and MyBiz M Sendirian Berhad, Lee Ting Fong was the claimant and MyBiz M Sendirian Berhad was the respondent. MyBiz M Sendirian Berhad allegedly failed to pay Lee Ting Fong's salary on time. As you guys can see in the animation, Lee Ting Fong faced constructive dismissal by the company. The last 2 months' payment was delayed, and she didn't get any payment for August too. However, the company failed to give any solid reason for that. Therefore, Lee Ting Fong wanted to take legal action. The legal issues in this case are, firstly, whether non-payment salary entitled employee to walk out of employment. Can Lee Ting Fong really walk out of employment when she didn't get paid? The second legal issues basically talk about whether MyBiz managed to settle arrears on in another word, dues of salary or not. Thirdly, whether company breached contract of employment entitled employee to consider herself constructively dismissed. Can Lee Ting Fong consider herself constructively dismissed when MyBiz Sendirian Berhad breached the contract? I think that is all for legal issues. There are 3 in total. Thank you.
Assalamualaikum and good day. My name is Dana binti Saleh and I will be explaining about the ratio decidendi of case Lee Ting Fong. Firstly, the respondent failed to pay the claimant's salary when it fell due, thus becoming a serious breach qualifying the claimant to walk out of the employment. It is not permissible for the company to delay or not pay the salary of the employees even if their financial position was insufficient. Forby, the company showed no evidence that they were trying to ameliorate collection and no evidence to prove the fact of insufficient funding from investors, as referred to case Adam versus Charles Zub Associates, 1978 IRLR 651, the Employment Tribunal. The negligence to pay an employee's wage in time is considered a breach of contract.
Good morning to Madam and my friends. I'm going to continue where Dinah left off. Going into the origin of the contract of employment, the non-payment of salary was a basic breach and a refusal to fulfill the contract by the company. This indicates that the company no longer planned to follow the employment contract. This led to the claimant being entitled to consider herself constructively dismissed. From the case mentioned, it's obvious that late of payment of an employee's salary is a contract breach. Due to this, the claimant is entirely entitled to walk out of the company and deem herself constructively dismissed.
On the 26th of September, she wrote a letter to dismiss herself from the company with immediate effect. The company ignored the claimant's letter alleging constructive dismissal by asking her to return back to work and convince her that the August salary will be paid duly. The company made no guarantee when her arrears of salary will be paid back and if it will even be paid. The claimant had nothing strong to retain.
An issue was raised by the respondent claiming that the claimant did not notify of the breach in the letter to give to the respondent a chance to rectify the breach. However, according to the evidence that was brought up by the claimant, she has shown her concerns as she was not being paid by the company towards the company's head of accounts department, the divisional head, and to the COW1. Hence, the respondent had multiple chances to rectify the problem. Lord Denning in the Court of Appeal case of Western Excavating Ltd vs. Sharp P226 stated that the employee is entitled in those circumstances to leave at the instant without giving any notice at all, or alternatively may give notice and say that he is leaving at the end of the notice. Hence, it is not a legal requirement for her to leave a notice before she considers herself constructively dismissed.
As the High Court decided in the case of Parima Ladevi anak perempuan P. Ponusami versus Mahkamah Perusahaan dan Skenia Southern Asia Berhad R312508 of 2007 Judicial Review, where the judge said, "Given the evidence, I felt the industrial court in this case had failed to consider the employer's conduct as a whole and failed to consider further that its effect, when judged reasonably and sensibly, could only be evidence of constructive dismissal." This was a case where the employee could not be expected to put up with it. For these reasons, I allowed the application for judicial review with cost to be taxed.
me and my team would like to say thank you for listening and focusing on our presentation. I hope that this presentation of ours can help you guys understand the case summary of Lee Ting Fong versus My Peace Malaysia Sdn Bhd. Thank you for listening.
Thank you.
Thank you.